Here I want to talk about the effect, or perhaps the lack of effect, of no strikeout application or a late strikeout application. It may seem obvious, but there have been no fewer than 3 cases very recently where the claimant has sought protection on costs, or in one case positively sought an order for costs on the basis that the defendant had not made an application to strike the claimant's case out for being so weak, or in one case where there was a successful but late application for strikeout, that the defendant should be deprived of costs. They seem to me, to be blunt, to be bizarre applications that a claimant brings a claim and then says, actually, my claim was so weak, so bad, so poor, so lacking in merits, that you, defendant, who I have sued, should have immediately applied to have it struck out. So I want to look just very briefly, and details will be on screen of the cases and my blog in relation to those cases, at the 3 cases. One is a case called Bailey and another v GlaxoSmithKline. That's a recent High Court case where the claimants lost in a product liability case, and this predated qualified one-way cost shifting, and so although a personal injury claim, the claimants did not have that protection, and they applied for the defendant to lose most of its costs for failing to have the claim struck out. What the court in fact did is to award indemnity costs against all of the claimants for bringing a claim which clearly could have been struck out. In an employment appeal tribunal, a case called Radia v Jeffries International, the Employment Appeal Tribunal held that a lack of a strikeout application was irrelevant to costs. Costs are not normally awarded in the Employment Appeal Tribunal, but in this case the costs were awarded against the claimant. In both cases, my feeling is that there's an element of the court potentially punishing the claimants further than necessary or further than normal because of, frankly, ludicrous submissions. So in the Bailey case, indemnity costs were awarded against the claimants, and in the Employment Appeal Tribunal case, actual costs were awarded, whereas normally no costs are. And if you stop for a moment and think about it, on dealing with costs at the end of the claim, to say my case was so weak it should have been struck out is almost an invitation to the court to award indemnity costs, or in the tribunal jurisdiction to award costs where otherwise they would not have been. And in a case called Ake v Newcastle University, again a very recent case, a late strikeout application was made, and the claimants, faced with that successful application, so the claim was struck out, argued that that should deprive the defendant of costs, as they should have made it earlier. That's the law. This is obviously a video, so I'll shake it up a bit. This potentially, if those decisions had gone another way, could lead to a bizarre form of no win, no lose claims, where instead of lawyers wanting a good claim so that they can win and get costs, they want a really bad claim that ought to be struck out so they can run it on, and then at the end say, our claim was so terrible, defendant, you should have struck it out, so you've got to pay our costs. The worst cases then will be ones where you don't know if you're going to win or you don't know if you're going to lose. So you can imagine setting up a whole practice based on taking absolute rubbish cases and then arguing that the other side should have spotted that and have them strike out. So no lose, no fee. It's the new coming thing. But on a more serious note, its applications by that, I realise we're all acting for our clients, but on these sorts of matters, claimants have no idea what's going on about strikeout and the rules. They're effectively acting on the lawyer's instructions. It's these applications that have brought the personal injury market or sector in particular into disrepute, and the end game of frankly ridiculous applications like that. The end game is what will come in 2021, which is a whiplash tariff and a substantial increase in the personal injury small claims limit. So you've got the details of the case that's been on screen, and you've got details of the blog on screen. And as ever, please feel free to make any comments.